Hai, Assalamualaikum warahmatullahi wabarakatuh. Salam sejahtera and salam satu Malaysia. We are for Group 7, which is an HLW. And firstly, we want to thank you for Madam Bella for give us an opportunity for present today. So our topic is the role of the law of the tort. So without wasting any time, I will introduce myself. Hi, my name is Siti Atika Shamilati Muhammad Radin, and I am from BCA. So I am the first presenter of today. So next we will move to introduction of the tort of the law before we go to our main topic. So the concept of the tort law is to redress a wrongdone to a person and provide a relief from the wrongful act to the others, usually by awarding monetary damage as compensation. The original intent of tort is to provide a full compensation for provide harms. So from the below, there are 8 types of torts, which is trespass, past imprisonment, negligence, and malpractice, nuisance, defamation, and the 2 last one is absolute liability and also vicarious liability. So next we move to So this topic is really a common topic that people will assume that crime and tort is the same law, but crime and tort is a different law, which is we can compare in here. For the first one is crime is a wrong arising from the violation of the public duty, but in meanwhile the tort is a wrong arising from the violation of the private duty. So here we can see that the crime is in a public, but the tort is in private duty. So the second difference of these two is crimes are present in the criminal courts. Meanwhile, the torts are present in the civil courts. So criminal and crime and tort are different courts to represent. So the last one is crime happen most intentionally. So it is a deliberate act which is people do to get some or unlawful benefits. But for the tort, it happen mostly due negligence. Tort is hardly intentional, but it's still damaging to the other individuals. So here is the difference of the tort and crime law. So next we move to our main topic, which is application and role law of tort. So a tort, as I mentioned again, a tort is a civil wrong that causes a claimant to suffer loss and harm. And then the first one of the application and role of tort is the tortious ability. So what is tortious ability? A tortfeasor insecure tort ability. In the other word, the tortfeasor who is found to be liable or responsible for the person's injuries will likely be required to pay the damage. And then liability in tort arises when a person does something that is not allowed or does not do something that requires by the law. So meaning of that is the person will be run the thing that required by the law. And the last one is tortious liability as arising from the branch of duty that been sanctioned by the law. So is tort and tortious liability is the same? People really wondering, do they the same? Do they are the same thing? So actually, tort is a word that come from tomtrun, which is mean to twist. What is twisted is the conduct of the wrongdoer. They call it defenders. And then such a twist cause an illegal injury that linked to a severe wrong to plaintiff, and the court provide a remedy to him or her in the law of the torts. Meanwhile, tortious ability arise from the branch of duty of fixed by the law. So there are a few mental elements in the tortious ability. So what does that mean? Okay, mental element is an essential in the most of form of in the crime. So it is not easy to make a night such on general about the liability in tort. So there are two elements in the tortious ability, such as fault when relevant, and the other one is liability without fault. Let's move to our next application and role of the tort law, which is motive and malice. So people wondering, what is motive and malice? Is that the other's name or what? So actually, motive and malice is one of role and application in the tort law. So let's go to motive first. Alright, motive is ultimate project, which is an act is done. But while an intention is the immediate purpose. So intention and motive is a different things. But meanwhile, we move to malice. When an act is done with bad intention, it's called a malice. So malice in fact refer to perform of an act which may be legal, but it will or had or in a bad intention. And then motive, and then we move to motive, which if motive is generally irrelevant in tort law, just like intentions. Okay, but motive leads to intention formation, which is the ultimate case. Sorry, not case but cause. So, what is a difference between intent and motive? So, although the motive and intent are often usually interchangeable, there are distinct concepts in criminal law. So, motive deal with individual underlying reason to commit a crime. Meanwhile, whereas intent are concerned with their willingness to carry out their specific action related to the offense. So, there are a different two things, which is intent and motive. So, here is example of malice. Malice is defined as a bad or will do desire to do bad thing to other person. An example of malice is when you really hate that person and you want to seek the revenge. So the state of the mind in the intentionally performing a wrongful act, intention to harm or depressive, in illegal or immoral way. So I think this malice example will be linked to Amber Heard and Johnny Depp cases, where Amber Heard really sick on revenge, and sometimes and the past cases that Johnny claimed that she abused her and cut her hand with the bottle and etc. So today the case is still going, and hopefully the case will be closed soon as possible. So that's all from me, the first presenter, and next I will pass to the second presenter. Assalamualaikum warahmatullahi wabarakatuh.
Assalamualaikum warahmatullahi wabarakatuh. Okay, my name is Muhammad Nur Hazman bin Hafizan. So, I will present about the application of intentional damage and imitation of tort. Okay, first is intentional tort. Okay, intentional tort. What the meanings of intentional tort? Okay, a tort is a type of wrongdoing that cause harm to others. This definition encompasses a wide range of actions, and the field of tort law is divided into many different subcategories. One of the way thought is solved is by the mental state of the person committing the offense. For example, a thought is known as intentional thought. Okay, an intentional thought occurs when a person wrongfully and intentional acts and that cause harm to others. They do not necessarily have to intend to cause the final decision of an intentional thought claimed to be valid, but they do have to intend to commit wrongdoing following most intentional thought case and civil law doctrine. Okay, so consequence of intentional thought and intentional injury can be severe and include bodily injury, emotional stress, property destruction, dangerous touch, offensive touch, loss of personal property, and other serious side effects. Okay, frequent example of intentional thought are intentionally inflicting emotional stress, feels imprisonment, dangerous of offensive relationship, trespassing on other people's property, battery, attempt or assault. Offensive touch such as abuse and fraud occurs. Okay, way to identify intentional thought occurring. Okay, although the individual component of intentional thought actions vary from case to case, there is something that can be looked for to identify the possibility of personal injury lawsuit of a similar civil suit. This can be brought by yourself or a closely related party. Okay, the first one is, did someone act with intent to contact at least one private citizen or another person? The second one is, did the tactile injury happen to someone else? Okay, the third, did relationship cause harm, injury, damage, or several emotional stress? And the last one is, did the victim permit to be contacted? Okay, intentional thought have 5 types. Okay, there are many different and common types of intentional thought. This range from physical abuse in person to extreme or outrageous behavior across the web and everything in between. They all cause injuries and damage. Okay, the first one types of intentional thought is battery. Okay, an intentional thought case for a battery is when a person mistakenly and intentionally touch another person. Okay, the relationship may be dangerous and hurtful, but it is not necessary to create a case under the principle of tort law. Okay, moreover, the intruder did not need to be aware of the battery going on for the plaintiff to bring such a case. Okay, the second type is false imprisonment. Okay, plaintiff can bring a tort case for false imprisonment if defendant unlawfully and intentionally incarcerate them for an unreasonable period of time. Okay, plaintiff must be aware of the confinement simultaneously. If they cannot prove this, then they must prove the real harm to establish the prima facie element of the cause of this action. Okay, the third is assault. Okay, thought intentional assault occurs when a person put another person in reasonable fear of danger. Okay, anxiety, mental stress, emotional trauma, and other negative effects evoked by the defendant's action are at the core of the case. Okay, for example, you may be attacked if someone puts a gun in your head. Okay, the fourth, invasion. Okay, invasion often referred to as encouragement into the land occurs when a person enters another person's land without proper permission or authority. This cover includes area above and below the actual plot of land in question. Okay, the last one is conversion. Okay, you can bring a conversion action against anyone who deprive you of your personal property, or maybe even if they just devalue or damage it. You can get the full value of the goods from the person accused of committing an offence in civil law. Okay, the next is damage in tort. Okay, damage in tort, the meaning. Okay, the meanings of damage in tort is usually a work to restore the plaintiff to the position he or she is in the tort does not occur. In law, damage are awards, usually in the form of money, that will be paid to a person as compensation for loss or injury. Damage are classified as compensatory damage and punitive damage. Okay, the damage in tort has types too. Okay, in a tort, the damage award by the court to the plaintiff may be classified into several heads. Okay, the first one is nominal damage. Okay, nominal damage are damage that although the plaintiff has suffered a legal injury at the hands of the defendant, no actual loss has been suffered by him. This damage are provided for in some cases where the court recognize the breach of the plaintiff rights, but the amount of damage is very nominal or low as there is no actual loss to the plaintiff. Okay, the second is insulting damage. Okay, in this type of damage, the court recognize that the plaintiff's right were violated, but to show that the suit brought by the plaintiff was so frivolous that it was only a waste of court time. The court award a small amount to the plaintiff as damage. This is the same as nominal damage, but the only difference between the two is that in nominal damage the plaintiff does not suffer actual loss, and in contempt damage the plaintiff suffer actual damage, but it is a trivial matter where he is not eligible to be fully compensated. Okay, the third is damage compensation. Okay, the compensatory damage are provided to help the plaintiff achieve his original position before a thought of commit against him. Okay, this compensation was not provided to punish the defendant, but to restore the plaintiff to his previous condition. Okay, this indemnity is very helpful in case of financial loss, where the amount of loss can be easily calculated, and therefore the amount can be direct to be paid to the plaintiff, so that he can replace the defective product or goods with that amount. Okay, the fourth is more severe damage. Okay, this indemnity is given for additional harm inflicted on the plaintiff which cannot be compensated by the compensatory. Okay, damage and it is given on factors such as loss of self-esteem, pain, and agony suffered by the plaintiff, and others that cannot. Okay, Therefore, these damage are additional damage award to the plaintiff, in addition to the damage award for his financial loss. Okay, the last one is punitive damage. Okay, these damage are also known as exemplary damage, and the purpose of the damage is to punish the defendant and be an example to him, so that others are prevented from committing the same act as he did. Okay, therefore, when the court felt that the defendant was very close, it award punitive damage against him to the plaintiff. Okay, so the last one is limitation of tort. Okay, first, the meaning of limitation of tort. Okay, briefly, it provides that if proceedings are commenced after the expiration of the statutory limit for the claim in question, the defendant may raise a defense that the proceedings are barred by law. Okay, there will be preventing any discussion of the merits of the claim. Okay, so the action limits. Okay, both claim for contract and tort claim are subject to their own limitation period rules. Okay, in most of current concurrent case, due to the length limit period, plaintiff prefer tort claims over contract claims. It is therefore important to explore the different limit period rules that apply to either tort claim or contract claims to find answer to the question, or whether the court allow complainant to rely on tort claim because of length of limitation period. Okay, if a complainant fails to bring a lawsuit within the required period time, the status of limitation will generally block his claim and dismiss it. Okay, effect of limit expiration. Okay, the effect of the limitation period is somewhat procedural rather than substantive, in that it preclude remedy and does not extinguish the claim itself. Okay, main limit period in tort. Okay, the current limit period can be found primarily in the limit Acta 1980 as amended by the Latent Damage Acta 1986 and the Consumer Protection Acta 1987. Okay, the basic principle is that tort action is subject to a limitation period of 6 years from the date that cause of action occurs. However, there are some important exceptions. Okay, some important exception is that the relevant period is 3 years in a tort action for damage for personal injury. This start either from the date that cause of action has occurred or from the date the injured person first became aware of his or her injury. Okay, the second is in the case of latent damage to the property considered below, section 14A and 14B, a detectability test is provided. Okay, the third is the normal limitation period for claim under the Consumer Protection Acta 1987 is 3 years on section 11A, whether for personal injury or other forms of damage according to the Acta. Also, 3 years is the limitation period for defamation claims on the section 57 of the Administration of Justice Acta 1985. The next is statute of limits for tort claim. Okay, the time limit for claiming or a tort varies from state. In the event of negligence, the complainant is usually required to commence a claim within 2 or 3 years from the date the cause of action occurred. Okay, status of limit under English law. Okay, the Limits Act 1980 govern the question of whether the cause of action of the complainant is constrained by the limit period. Okay, if the plaintiff does not initiate his claim for the right of remedy within the prescribed period time, the action is barred. Okay, in such circumstance, the complainant has the burden of proving that within the limitation period his claim was accepted. Okay, the last one is status of limits for tort. Okay, it provides that action based on tort shall not to be brought after the expiration of 6 years from the date the cause of action occurred. Okay, while the cause of actions around the date on the defendant's wrongdoing in a tort case can be prosecuted. In a negligent case that can only be brought based on evidence of damage, the cause of action occurred at the time the damage occurred. Okay. In addition, a period of 3 years is a special time limit for self-injury action. Okay, the rules state that a period of 3 years applies to. Okay, in the event of negligence resulting in any form of talent damage recoverable, okay, the action shall not be brought after either 6 years from the date the action arose of 3 years from the date the complainant became aware of certain facts required to bring an action for damage if this period expired later. Importantly, only tort claims are covered by the latent damage provision contained in section 14A of the Limit Act 1980. Okay, that's all from me.
Assalamualaikum warahmatullahi wabarakatuh. My name is Anisha Fahmi from Bachelor in Culinary Art. So today I'm going to present about objective of the tort law. The next slide. Okay, introduction and objective law. Tort law. Okay, a tort is something that occurs when one person negligence directly causes property or personal damage to another individual. So the objective of the tort law has several, such as first one is to restore the victim to the place they were at before the injury occurred. Second is to create a system where victim can redress without resorting to vigilant justice. Third is to punish the wrongdoer in cases where the wrongdoer acts maliciously. And last but not least is allow victim to seek redress outside of the criminal system. Okay, for the next slide is compensation tort law. Okay, according to the principle of full compensation, tort law seek to put the victim to the position he was in before the tort. This position is generally considered to be a situation where the victim does not suffer any harm at all. It considered an alternative interpretation if an injured that due care the victim is faced with expected harm. Okay, this can be considered the victim expected harm is the situation he was in before the tort. Okay, the compensation for physical injury include consideration of the past and future economic losses, as well as monetary certification for a variety non-financial items of damage, such as pain and suffering or loss of amenities, which are amenable to precise mathematical calculations. Okay, for the next slide is protected interest of tort law. Okay, definition of the protected interest. Okay, the restatement of the law or of tort second use the term interest to denote an object of human desire. These interests range from interest in physical security and autonomy in enjoyment of one physical property or person to interest in emotional security and intangible interests such as privacy to interest in economic security and opportunity. Okay, besides, tort law recognize a variety of protected interests from a formal modeling perspective. This can be thought of as a bundle of tangible and intangible goods. The most commonly protected interest can be thought of party interest in the pre-injury bundle of goods. If a drunk driver happened to crash into a garden wall, the garden owner has reasonable to assurance that the driver can be held liable for restoring the wall to its pre-injury condition. Besides, in some circumstances, a party may not have had the actual enjoyment of the party prior to injury, but only the expectation of its future enjoyment. Next slide is tort law also aims to protect individual interests from a harm that is actual or treated. However, and not all interests are protected, and some benefit from better protection than others. Okay, this is a result of the importance of an interest reflected by society through the years. Okay, the interests protected include personal harm to property, harm to reputation, harm to financial interest, and harm to the due process of law. Okay, that's all for the objective of tort law. Next, I will pass to the next presenter. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nurul Azima binti Fauzi from BCA, Bachelor in Culinary Art. I will do a presentation in the section Deterrence, Punishment, Workful Conduct and Conclusion. For the deterrence section is Torts law have a preventative effect, encouraging people to take fewer risks and carry out their activities more carefully, taking into account the possible impact on other and their property. Therefore, in its modern economic sense, prevention aims to reduce the number of accidents by imposing high financial costs on unsafe behavior. Distinctions is necessary between specific and general prevention. The first depends on the effect of contempt on the law of thumb. This element of prevention, however, is almost completely lost in the case of wrong accidents, where the danger is statistically unavoidable and in most cases stem from memory indifference, the occurrence of which cannot be avoidable by the guarantee of terms. Third, therefore, term law is in some case the second best way to prevent accident after criminal law. Second slide. Okay, for the punishment of wrongful conduct in tort law, also play a small role in tort law, as there is symbolic moral value in obligating the offender to pay the victim. In any case, Tom and criminal law indistinguishable and all touch the two breasts big to acquaint independence identities. The former remains in the shadow of the latter of a long time. Offenses against social and the interests of the king were increasingly the subject of criminal law, which offers against the individual will were dealt with by emerging to law. However, the initially tort law only applied to the most serious types of offense, bodily injury, damage to goods or damage to goods and trespass. Okay, next. For the conclusion, third is a cyber offense distinct from breach of contract, where the law provides of damage. The basis of modern tort law derives from damage for trespass and trespass on the case. Therefore, the law of term determines where there are loss inflicted on the victim should or should not be attributable to other. Some proceeds from the offence committed, such as medical costs, that had to be paid, can be compensated. Compensation can also be paid in cash for not monetary outcomes, such as pain sufferance. However, as a Malaysia social, we should be careful in community wrongdoings because our country has national laws that have been set. Okay, that's all from me. Bye-bye.